just let him. एक second, just let him. Okay. जरूरत नहीं है. Good evening, everyone. I request Mr. Vikas Singh, President SCBA, Mr. Rahul Kaushik, Vice President SCBA, to kindly escort Honorable Mr. Justice Abhay S.O., Judge Supreme Court of India, and the Honorable Chief Justice of India, Honorable Mr. Justice Bhushan Ramkrishna Gavai, along with Mr. R. Venkatramani, Learned Attorney General for India, to the dais. Yes, sir. Thank you, sir. We welcome Honorable Mr. Justice Abhay S. Oak and thank him and his family members for accepting our invitation for gracing this occasion. We welcome the Honorable Chief Justice of India, Honorable Mr. Justice Bhushan Ramkrishna Gavai, for accepting our invitation to preside over this function. I welcome Honorable Judges of the Supreme Court of India, Honorable Judges of various High Courts, and Honorable Retired Judges of the Supreme Court and High Courts for gracing this occasion. I also welcome Mr. R. Venkatramani, Learned Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General of India, and all the learned law officers who are present here. I also welcome Mr. Kapil Sibal, Senior Advocate, ex-President SCBA, four-time President of the SCBA. I also welcome Mr. Vipin Nair, President SCORA, and all the senior advocates present here and members of the bar. Before we begin, I request the Honorable Chief Justice of India, the Honorable Judges of the Supreme Court of India, and all the esteemed guests to present here to kindly stand for 2 minutes in silence in memory of late Mrs. Vasanti Oak, mother of Honorable Mr. Justice Oak.
It is with deep sense of admiration and respect that we have gathered here today to bid farewell to a truly exceptional individual and a distinguished judge, Honorable Mr. Justice Abhay S. Oak. Justice Oak's tenure, characterized by his deep commitment to constitutional rights, judicial integrity, and social justice. His judgments reflect a balance between legal rigor and empathy, leaving a lasting impact on Indian jurisprudence. As he approaches retirement, his contribution continued to inspire both the judiciary and the broader legal community. Sardar Vallabhbhai Patel was once arguing a case, and in midst of his arguments, his court clerk handed over a slip. He read it and kept the slip in his pocket. He continued and completed his argument, and after the matter was over, he left the court. The news of demise of his wife was mentioned in the slip. The remarkable incident shows the extraordinary commitment to sense of duty which he had. A similar level of commitment to work ethics was displayed by Justice Oak today, when despite the demise of his mother, he returned to attend the court on his final day and delivered 11 judgments. Sir, we salute you for your extraordinary commitment to the cause of justice.
Besides your Lordship's outstanding achievement, both as a lawyer and a judge, the members of the bar will always remember you for making us work a bit more harder on our briefs than usual, so that we could keep up with the pace of my lord. We are grateful to my lords for teaching us the virtue of being brief and to the point of argument. Implementing the said virtue of brevity, I conclude, and I now request Mr. Rahul Kaushik, Vice President, SCBA, to give his welcome address on this occasion.
Honorable Mr. Justice B.R. Gavai, Chief Justice of India, Honorable Mr. Justice Abhay S. Oak, Judge Supreme Court, family members of Justice Oak, Mrs. Anuja Oak, wife of Justice Oak, Mr. Akshay Oak, Akhil Oak, Divya Dhage, daughter-in-law of Justice Oak, Honorable Judges of the Supreme Court, Mr. R. Venkatramani, Learned Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General of India, other law officers, Shri Vikas Singh, President SCBA, Pragya Baghel, Honorary Secretary SCBA, Mr. Vipin Nair, President SCORA, Mr. Amit Sharma, Vice President SCORA, and Mr. Nikhil Jain, Honorary Secretary SCORA, Senior Advocates, and my fellow colleagues at the bar, a very good evening to you all. On behalf of the whole Executive Committee, I welcome you all. I also wish to congratulate Honorable Mr. Justice B.R. Gavai, Chief Justice of India, who took over as Chief Justice of India 10 days back. And in this period of 8-10 days, he has already done two things which were really an issue in the bar. That is letter circulation in which new guidelines have come, and the sequence of all courts which were coming in the morning would now come up in the supplementary list in the evening or day before, and lawyers can plan for their matters accordingly. Justice Gavai was member of the Chamber Allotment Committee when 500 lawyers were allotted chambers in D Block Additional Building Complex, along with Justice Suryakant and Justice A.K. Maheshwari, and a demand to build cubicles on ground floor, first floor and third floor, excepting 70 lawyers were allotted cubicles also. Sir, the bar has a lot of expectations from you. You were the member of the Chamber Allotment Committee when 500 lawyers were allotted chamber 3 years back. It's a request if the formalities can be completed fast for the 1.33. Yes, I missed that, yes. In fact, I was coming to that. 1.33 acre land near ITO so that more chambers can be constructed for lawyers there. Just a request also, if the museum which has been made in the earlier judges library can be shifted somewhere else, as it is in the high security zone and not many people come there, and the space can be utilized for conference room and other facilities for lawyers. Not many of you are aware when we never used to get this hall. Justice Gavai, along with the other honorable judges who were in line to become Chief Justice of India, came with us. I was secretary at that time, and Mr. Vikas Singh was the president. They came on a Sunday, and Justice Gavai said, in Bombay High Court, we gave one of the court for the farewell, so why not an auditorium for the lawyers? So this is what he said that time. Now coming to Justice Oak, for whom all of us have gathered here, who is retiring today, it is both a privilege and an emotional moment for me to stand before you today, to bid farewell not just to a judge, but a judicial institution in himself. Honorable Mr. Justice Abhay S. Oak hails from a family with legal background, as his father, Srinivas W. Oak, was a renowned lawyer. He did his bachelor's in science from Mumbai University and decided to become an engineer. However, destiny had other plans, and he did law and enrolled as an advocate on 28 June 1983 and started practicing in Thane District Court in the chamber of his father, Srinivas Oak. In 1985, he joined the chambers of Sri V.P. Stipnis, a former judge of the Bombay High Court and former Lok Ayukta, and thus practiced for around 20 years in the Bombay High Court and appeared in several important matters in public interest litigations. He was elevated as additional judge of the Bombay High Court on 29 August 2003 and appointed as permanent judge from 12 November 2005. He took oath as Chief Justice of High Court of Karnataka on 10th May 2019. During his tenure as a High Court judge, he passed many orders on environmental protection and for better living conditions in Bangalore and Bombay. He is known for his orders on civil liberties. During the COVID-19 pandemic, he passed several orders protecting the rights of migrant workers, standing up for the right of privacy, or his strong view against handcuffing of accused, calling it a direct assault on Article 21. Justice Oak more than lived up to his name Abhay, which translates to without fear. This is not the only admirable quality that he has, though. During his tenure as Chief Justice of Karnataka High Court, he personally welcomed back a staff member of the court who had recovered from COVID-19. Justice Oak had monitored the health of every judicial officer and staff member who had contracted the virus, which shows his human qualities. Justice Oak believes that if one must succeed in the High Court, to succeed in the High Courts or Supreme Court, they must spend a few years as a lawyer in trial courts. He has credited his success to his time in trial courts. Justice Oak said that district and taluka courts play an important role in providing justice to common people. Therefore, they are the core of the judicial system and should not be looked upon as secondary courts. He took oath as judge of the Supreme Court of India on 31st August 21. During his tenure of around 4 years, he passed several landmark judgments, be it the guidelines issued recently for the senior designation, Angadwari workers entitled to receive gratuity under the Payment of Gratuity Act, upholding the validity of All India Bar Examination, other important judgments. He never differentiated between a raw junior with 1 or 2 years experience and the senior most lawyer in this court. The only thing which mattered in his court was you have to be very well prepared. And even if there were 70-80 matters listed in his court, he was more prepared than the lawyers. He always believed that personal liberty of a person is also very important and was very liberal in granting bail in matters where the trial was taking long. Justice Oak is a workaholic, and in the farewell organized by the scorer recently said that he does not agree with the tradition of retiring judges not working on their last day, and said he would be sitting in a regular bench and pronouncing some judgments. And he did so, and around 11 judgments were pronounced today before the ceremonial bench sitting in court 3. Some of my friends from Bombay told me that even while traveling from Thane to Bombay High Court in the car as a judge, you would always find him reading briefs. And just speaking about the person, he lost his mother and the next day he is in court. In one of the functions organized by the Advocate Association of Western India, Justice Oak said, "I don't believe in the philosophy that if you retire, you get freedom. He believes that as a judge, you get greatest freedom to do justice, which you will not get outside the judicial world." He went on to say, "I always believe that when you are a judge, you should not do anything to make your presence felt. Your success will be counted if your absence is felt if you demit office. So your absence will be felt by all of us over here." Justice Oak believes that it is high time that successful members of the bar and senior advocates should come forward and conduct at least 5 legal aid cases every month. Sir, as you take your next step in life, the robe may rest, but your legacy may never retire. It will speak through every judgment, every citizen empowered. Before I close, I also with a heavy heart express my condolences to the whole family of Justice Oak on the recent passing of his beloved mother, Srimati Vasanti Oak, just 2 days back. And while she may not be physically with us today, one can only imagine her watching with pride from heaven, knowing that her son served the highest court of this land in nothing but honor. Now just a few words for Justice Oak. Oak, a name that echoes justice. O for order, he never let it sway. K for the kindness in every word he had to say. A for the anchor of rights in dismay. Justice Oak led law in the noblest way. He spoke for the silent, stood for the just, with a spine of steel and a heart of trust. From Thane to top, his journey is a flame, and history shall whisper forever his name. Thank you.
Thank you, Mr. Rahul Kaushik.
I request Mr. R. Venkatramani, Learned Attorney General for India, to kindly address on this occasion. So you have to do first.
How do we bid a farewell to a great and discerning mind, the mind of Justice Oka, whose mind and heart never minded towards rest as ordinary mortals like me would like to snatch? How do we say we allow you to depart from our midst, from the engaging job of doing justice, even while you never wish to stay away from eating or talking or thinking, and even sleeping with thoughts of justice and doing justice. So it is, one can say, that even as retirement by reason of age may come, we are here today to tell you, great judge, that as long as your mind wishes to explore the frontiers of law and justice, let it be your treasure. Further, I stand here as a Lilliputian, too small to capture a pen portrait of your seminal contributions to law and justice. This work occupies a tall space along with those great judges who shaped the contours of the Supreme Court to be what it is today. I was grappling with a job, a pleasant job of drawing a portrait of your incisive reflections on shaping the course of justice in every case that came before you. Farewell speeches are not rituals. They are thoughts which sincerely come to us. I do feel so good about what I may like to say about you as a humanist and as an explorer. Democracy, informed by constitutional law, has given us expectations, the law that people did not have, let us say, at the time of the enactment of the Constitution. We live in an age of unbounded confidence in the value and efficacy of law as an engine of social and moral improvement. The spread of parliamentary democracy across most of the world has invariably been followed by rising public expectations of the state of which the courts are a part. The state has become a provider of basic standards of public amenity, the guarantor of minimal levels of security, and increasingly, the regulator of economic activity and protector against every misfortune of every kind. The public expects nothing else. Yet protection at this level calls for a general scheme of rights and a more intrusive role for law. People have expectations of the law today they did not have probably in Koch's time or some 60 years ago when the UN Charter and the Universal Declaration of Human Rights came to be drafted. Popular expectations of law are by historical standards exceptionally high now. All this calls for constitutional discourses and the exercise of a discretion of a high ordering in the courts. The wide spectrum of subjects and issues that have been scanned by Judge Oka is a window into how you grasped the importance of this high ordering. I think it came to you both naturally and by your earnings to do justice by doing justice. I quote what Sir Edward Coke said about discretion. I quote, "Discretion is a science of understanding, to discern between falsity and truth, between wrong and right, between shadows and substance, between equity and colorable glosses and pretenses, and not to do according to their men's private will and private affections." I quote. I should say that Judge Oka practices this discretion beautifully as your justice learning mind persuaded you. Let me illustrate by a few instances in a remarkable way. In the case of Adivasis for Social Rights Action case, you dealt with the rights of non-tribals residing in scheduled areas, a matter of great sensitivity and balance between sections of the community demanding social and economic fairness. The non-negotiable importance of freedom of thought, expression, and conscience always remained as an animating idea with you. While as the Chief Justice of Karnataka High Court, in the context of the curfew imposed under Section 144 CRPC, you rightly said that peaceful protest is a basic feature of the Constitution. I find that what you said in the case of Sanjay Anand Salve going to the rescue of a school teacher from his suspension who wished not to fold his hands during school prayers because of his belief was no less important and poignant than what Supreme Court said in Vijay Emmanuel case and what US Supreme Court has said in the Yehovah Witnesses cases. Equally clear, you were in Javed Ahmad Hajam case that every criticism or protest of a state action being an integral part of the right to dissent calls for protection under Article 19(1) in the Constitution. You were so wedded to liberty that you were clear in telling a state government that property demolitions without due process can be no part of our constitutional fabric. Very often, when I've been in your court, I used to recollect my nascent days in this bar appearing before Justice Krishna or Justice Chinnappa Reddy and reflect on the importance of the principle that when you are in doubt, lean in favor of liberty. You will be remembered not as a spaghetti spine. You verily believed that cruelty to animals can be no part of human values or behavior. On the same lines of thought, you protected the right to privacy when it came to dealing with the Maharashtra Animal Preservation Act, much ahead, the Supreme Court laying its thoughts on privacy. Your deep commitment to ecology and environment took you to holding the judicial whip very firmly, which is reflected in hearings of the MC Mehta series of applications. The orders you passed therein are disapproving relaxations in matters of environmental notification, including your non-approvals of executive laxity in tree cuttings, though seemingly small but significant for due process. As one scans how you dealt with criminal justice, it seems that by some magic wand in your hands, you came to know the line between needed acquittals and justified convictions. Every criminal case you dealt with bears its mark, and one can cite a larger number of instances to underscore this. This work was, however, clear on policy domains of government, though the inclination to sit in judgment over policy matters is always attractive. Robert Hildbronner, in his book, An Inquiry into the Human Prospect, on going to the roots of matter in inquiry, wrote thus, I quote, "If radicalism is to go to the roots, as the term implies, it must be prepared to examine the nature of man in ways much more courageous and much less pietistic than those it uses in the name of humanism. Only on such basis it can hope to build ideas and programs that will be able to withstand the tempest of events whose source lies both as challenge and response within men themselves," I quote. I say that this is, however, possible only if the mind understands and inclines and yearns to know the roots of human suffering and joy and of man's existential burdens, perceive human inequalities as historical processes, is concerned with understanding the great capacity of human mind to choose and promote economic and political process as most appropriate to realization of human freedom from the clutches of wanton greed, recognize the right to dissent as germane to the struggle for total human freedom, only if the mind is not close to inquiry and reform. Justice Oka's mind was wedded to this sublime inquiry. The bar is not bidding farewell, but wishing a great reflective and productive life ahead, beyond SLPs. You may serve many causes beyond cost lists. Let your family cherish great memories and remind you of taking some time for them, and to you too, I wish you a great life.
Thank you, sir. We agree with you. The farewell speeches are not just speeches, but our way of showing respect and affection to the judge. Now I request Mr. Vikas Singh, President, to kindly address this august gathering.
Honorable the Chief Justice of India, Justice B.R. Gawai, Honorable Judges of this Court, learned Attorney General of India, learned Solicitor General of India, law officers of this Court, members of the family of Justice Abhay, members of the Executive Committee of the SCBA, Shri Vipin Nair, President SCORA, members of the Executive Committee of SCORA, members of the Bar, ladies and gentlemen. We have gathered here today to bid farewell to one of our most dynamic and progressive judges of this court of today's time. It is indeed an honor for me to do this farewell for Justice Oak, and in my 10 years as a President of the Supreme Court Bar, I've had the privilege of doing this for such fearless judges like Justice Nariman and Justice Oak, and that really makes me a very proud President of the Bar. I personally feel that 65 is no age to retire. And the way we see Justice Oak, the way he has worked till now,
I think this is definitely a matter which needs to be rethinked, and the government can do well to do this, because not wasting the talent of a judge, wasting the legal acumen of a judge at the age of 65 actually is a waste to the system. We are also grieving the death of his mother, Srimati Vasanti Oka, who died yesterday, and the commitment of Justice Oak to the profession and to this institution, and his sense for cause of justice is displayed by the fact that he missed court only for one day, and he is back with us today here, and he proposes to stay on. I was just chatting with Justice Oak about what will be the future of what all is to be done in the family with regard to the bereavement that has happened. He said his father and mother both had written down very clearly that there will be no grieving, there will be no religious ceremony, and life will go on notwithstanding the death of either his father or his mother. And that is why even after the death of his father, he was back in work the very next day. And even after the death of his mother, he is back in Delhi in court the next day. The only solace is that in the case of his mother, although maybe he may be back for one day, but now he will have more time to himself. And really speaking, his work will be much lesser. So his mother, while going away, has given him a gift of at least his time, which he will be able to devote for himself. There are several jurisdictions where Justice Oak has done amazing work, but I would like to mention 2 or 3 of them primarily. One is the PMLA. As a judge sitting in a division bench, he had a 3-judge bench of Vijay Madan Lal Chaudhary, which had laid down that an accused has no right to an ECIR. The statement of the accused is admissible even if made in custody, and he can be charged of an offense notwithstanding whether the date when he committed the offense, it was an offense or not. So really speaking, Article 21, 23 and 21 had been interpreted by the judgment in favor of the government, or rather against the persons accused. Now, grappled with this kind of a judgment to deal with and still try to give relief to people to at least save them from the draconian provisions, Justice Oak has done human service to the cause of justice. He provided that a grounds of arrest should be given to an accused when he is to be arrested. He ruled that even if you are having some not relied upon document, which normal in criminal law is not to be supplied to the accused, but he said even that needs to be supplied to the accused, because there could be something favorable in that which could be used by the accused during trial. Now these provisions are, these kind of authorities are so salutary, because in some way at least there is solace for the accused if they are being subjected to a draconian provision of law. The other jurisdiction which I would like to mention is the jurisdiction in the matter of environment. Justice Oak has taken the cause of environment as if there is some personal, commitment to the cause. The way he handled the environmental bench, the way he was so strict. I remember in Delhi, when CNG was first being thought of, there was a huge hue and cry that if CNG is started, there'll be no petrol pumps giving enough CNG and people will be suffering badly. That time also the environment bench took a very strong call and said that no, it has to be implemented, happen what may. And for a couple of years, the environment remained better. Similarly, Justice Oak has taken several steps, including having the tree census, also of ensuring that the maximum within the framework that can be done for the purpose of cleaning the environment should be done, because Delhi, amongst the cities of the world, is one of the most polluted cities in the world, and every step taken in that direction is really commendable, and we must all appreciate the human work done by Justice Oak. Whenever a litigant comes to the Supreme Court, or for that matter in any court, the expectation is to get justice. And when it comes to the court, one expects that one will get justice and not be bogged down by technicalities. I have the privilege of saying, the Solicitor General has mentioned that he was on the other side. Of course, he said it with a great amount of sport in the morning. We have been on this side. We have had the benefit of his judgments. The fact that he was ready to give relief to a common man, to a common lawyer, if he had made out a case, speaks how well this institution has been under whatever jurisdiction that he dealt with during his tenure. Everybody, regardless of whether he was rich or poor, whether he was well represented or not represented, whether it was a senior lawyer or a junior lawyer, everybody got relief in his court, and that really speaks volumes of what we expect from the judiciary. Even for the lady lawyers, I was informed today that he used to encourage lady lawyers, and a large number of lady lawyers were appointed as amicus. And that also is a huge help, because we have seen so far this profession is quite skewed, and there is not much of representation, especially amongst the ladies at least in the senior positions in the profession, including in the judges ratio. But he was always encouraging to the lady lawyers. He was always encouraging the young lawyers. No young lawyer ever felt intimidated in his court, even if he was not having a bad case. I have seen instances where a lawyer may not be knowing his best case, and Justice Oak provided him with the relief because he had read the brief and he was aware what could be done for that particular junior lawyer, and the junior lawyer was given relief. In the Bombay High Court, Justice Oak took a view that in domestic violence, a 482 cannot be used for the purpose of quashing a criminal case. Recently, he has delivered a judgment here where he acknowledged that his view in the Bombay High Court was wrong. He has upturned his own view, unlike many others who have actually taken a recourse to supporting the view that they have taken, and has said that I was wrong and I need to rethink on that view, and he has accordingly changed that version. This is my tenure is starting today, so really speaking, I would like to use this opportunity to also make a couple of demands, which is of course not anything doing with Justice Oak, but I'm sure while going, Justice Oak will also make some recommendation to the Honorable CJI for the members of the bar. The demands are that the chamber construction, sir, has been hanging for a long period of time. There easily about 1,000 chambers can be constructed. We have a large piece of land, and enough space is there with the Supreme Court to house whatever they want to do in that building, rather than doing it here in this additional block, and provide at least 1,000 chambers. And that construction, sir, can start. We can use this for the holidays for starting that. Mr. Rahul Kaushik has already mentioned the museum is wrongly located. It is in a high security area. Hardly anybody visits there. It can be easily used for the bar. That can be used for providing cubicles, air-conditioned cubicles, where members of the bar can do online work outside or also meet clients. And the height of that room is so much that easily there could be 2 or 3 layers of cubicles in that area which can be constructed, and that construction, sir, also can start now. The canteen, which is presently there, is very, very small on the first floor. That can be enlarged by taking a part of the library 1 and providing us a library on the 1B side where a lot of place has been vacated by the registry. And sir, lastly, why I'm mentioning these things today is because we are going in recess, and if these things are accepted, probably some work can happen during vacation. The corridors are not air-conditioned, except the front portion of the Supreme Court. The entire corridor should be air-conditioned, sir. That will relieve the courtroom of a lot of people who get accumulated there, and it becomes very difficult to enter courtrooms. So these are some of my demands which I would like to make, and I request Justice Oak to also put in a good word on our behalf for what we demand. Justice Oak has been a workaholic. I just now was told by somebody that he used to ask the Chief Justice that you can give me more than 60, you can give me 70 also, you can give me 80 matters. Normally judges say don't give me more than 70, but he's the one who used to say give me as many number of matters. He would read at night, he would read in the morning, be prepared in all of them, and has done huge service to this institution. Justice Oak is fond of his morning walk. He's also fond of photography, of reading, of watching cricket. I wish him all the very best. I feel that now he will be, because I just talked to him, he said he's not intending to do any arbitration, he'll just be doing opinions, etc. So basically I feel that he'll have more time to himself and he will be able to pursue his passions, which is of photography, reading and watching, and also spending more time with his family. Today his sons Akshay and Akhil are also here. Both of them are not lawyers, but his daughter-in-law, I just realized, I was told that is a lawyer. So probably at least there is somebody in the family who is pursuing the profession of law. And I wish Justice Oak and the entire family a very good third innings, so to say, and also a very happy, healthy future life. Thank you.
Thank you, sir. I just got to know that Justice Oak, in his first 12 years of judgeship, did not take a single holiday, and very few thereafter. With this, I request Honorable Chief Justice of India to kindly give his address on this occasion.
My dear friend for last 40 years, and whose journey we are all assembled here to celebrate, Honorable Justice Abhay Oka, Srimati Anuja Oka, and family members of Justice Oka, my esteemed sister and brothers from the Supreme Court, Shri R. Venkatramani, the learned Attorney General for India, Shri Tushar Mehta, the learned Solicitor General, and all other law officers of the Government of India, my esteemed colleagues from Bombay High Court, past and present, my colleagues from Karnataka High Court, Shri Vikas Singh, the President, Supreme Court Bar Association, Shri Rahul Kaushik, Vice President, Pragnya Baghel, the Secretary, and all other newly elected members of the SCBA, Shri Kapil Sibal, the immediate past President of the SCBA, Shri Vipin Nair, the President of SCORA, and all other office bearers of SCORA, the Secretary General of the Supreme Court, the registrars, and the staff members of the Supreme Court Registry, and the members of the Supreme Court Bar Association. Good evening to one and all. Before I begin with my speech, I think this is my second farewell speech. The first one started when I was here to bid farewell to the Honorable Chief Justice, Justice Sanjeev Khanna. And I think Rachna ji is here. So she started making demands even before I had taken the oath. Kapil ji said that gifts are not demanded. They should come naturally. When my turn came to speak, I said that at least with my past track record, you should not have any apprehensions. So, and therefore, though Rahul and Vikas ji have made several demands, this is not an occasion to reflect on that. I think I had rightly rejected the request of Mr. Vikrant Yadav for a felicitation by the SCBA. I think I will reiterate that. Immediately after I took over as CJI, we had a chamber meeting on the very next day because Justice Vikramnath and Justice Dulia were to leave on the other day. And we have taken various decisions, like the permission to circulate the letter, the sequencing, which creates a lot of problems. So we have requested all my colleagues that they should give the sequences by 5 o'clock prior evening so that they can be published in the supplementary list and the lawyers can arrange their diary accordingly. The other decision that we have taken is with regard to removal of the glass partition, which was demanded by the bar for last several months. So I think when all of you come back after partial working days, I'm yet to get used to it, you will see the Supreme Court in its original facade. Now, let me come to my speech. I'll begin my address by asking a simple question. How many of you know about Anganwadi workers? Except my colleagues from the Bombay High Court and, of course, Justice Orade, very few must be knowing about it. The Anganwadi workers are crucial frontline workers in India's public health care and education system, focusing mainly on children of 0 to 6 years. These workers serve as vital agents for early childhood education, healthcare services, and holistic child development, and assistance to women during maternity. These workers are instrumental in combating issues like malnutrition, infant mortality, and preventable diseases. There are many such unsung heroes in the country, and particularly in the remote tribal areas. These Anganwadi Sevikas, Anganwadi workers, do a wonderful work. Despite their crucial role, Anganwadi workers face numerous challenges. One such issue faced by them was non-payment of gratuity under the Payment of Gratuities Act 1972, which mandates employers to pay gratuity to their employees as a form of compensation for their long-term service. When the Anganwadi workers approached the Supreme Court, it was held that the Anganwadi workers are entitled to gratuity under the 1972 Act. You may ask, why speak of Anganwadi workers at a farewell function of Justice Oka? It is because the judgment of the Supreme Court was authored by none other than Justice Abhay Oka. For in the silence of neglected lives, he heard the quiet call of justice. With the stroke of his pen, he wrote not just a verdict, but restored the faith of thousands. And so today, as he steps into a new chapter, let us not only celebrate a career of wisdom, but a legacy where the smallest voices were not only heard, but honored. This is Oka's distinguished career, spanning over 4 decades, including more than 2 decades of exceptional service on the bench, reflects his commitment to justice, both as an advocate and as a judge. I recall that even in those early years of practice, Justice Oka had earned a reputation as a lawyer who combined intellect with meticulous preparation. He complemented his brilliance with tireless hard work. Whenever he stood in court, he was exceptionally prepared, a practice that he still maintains as a judge of the Supreme Court. Over his distinguished 16-year tenure at the Bombay High Court, Justice Oka earned a recognition for his commitment to principles of fairness, accountability, and safeguarding rights. Justice Oka's name became synonymous with upholding rule of law, ensuring transparency in legal proceedings, and championing the protection of individual liberties. On a personal note, our journey has always been simultaneous. We started practice in Mumbai almost at the same time. After 5 years, I shifted to Nagpur. We became judges almost at the same time. He became in August, I became in November. And then in 2019, when I was given a hint that I'm being called here, Justice Oka and one another colleague were senior to me. And I went to his chamber and I told him that I have got such a message, so what should I do? He said graciously that the Bombay quota is already full, and I know that you are not going from Bombay quota, and if you go from some other quota in which I can't go, and if my friend is getting an opportunity to become Chief Justice of India, I'll be most happiest person. As I said in his felicitation at Mumbai in 2021, organized by the Bar Council of Maharashtra and Goa, that there has always been a healthy competition between us. A competition, but a healthy one, not a unhealthy one. As to how to do our best to impart justice to the last man, to the common citizens, we have strived our best in that manner. A couple of months ago, I received a message from him on my mobile. Here, after every retirement, I think Supreme Court Observer publishes the numbers of judgments of all the judges, how many judgments they have delivered. And so he said, you are number one. And I replied to him that I may be number one in total, but on annual average, you are the number one. And I'm sure that you will be surpassing my number in no time. And I'm sure that by now, because I don't keep track record, but my highest number must already been crossed by him. After being appointed as the Chief Justice of Karnataka High Court in 2019, Justice Oka initiated a series of impactful administrative reforms. A defining feature of his tenure was his proactive leadership during the COVID-19 pandemic. The Karnataka High Court emerged as one of the first in the country to implement virtual hearings, thereby ensuring uninterrupted access to justice. In addition, he prioritized strengthening judicial infrastructure at the grassroots level. Several district court complexes constructed during his tenure came to be regarded as model court buildings, reflecting his commitment to institutional improvement and accessibility. As a matter of fact, Justice Oka, myself, and two of my colleagues present here, Justice Revati Mohitere and Justice Makarand Karnik, we also had an opportunity to work on the Infrastructure and Buildings Committee of the Bombay High Court. And I must say with pride that in our tenure as a member or chairman of that committee, we could do a lot for providing good infrastructure for judiciary in Maharashtra. As a matter of fact, the land on which the new High Court building is to be constructed in Bandra, the groundbreaking ceremony of which was done by the then Chief Justice a couple of months back, is only because of the judicial order passed by Justice Oka in Bombay on the judicial side that we got such a big piece of land. On the judicial side, Justice Oka displayed a keen sensitivity to the rights of persons with disabilities, directing the state governments to prioritize their vaccination during the pandemic. Such orders have underscored his human approach to adjudication and also reinforced the judiciary's role as the protector of marginalized communities. Justice Oka's elevation to the Supreme Court in August 2021 was not just a new chapter in his remarkable judicial journey. It was for me personally a moment of reunion and joy. Our paths have intersected closely over the years, first as lawyers in the Bombay High Court, then as colleagues on the bench, to find ourselves once again together in the Supreme Court felt like coming a full circle. I feel privileged that I get an opportunity to have this function when I am here as the head of the Indian judiciary. I must say that we not only talk about diversity and inclusiveness, but also practice it. The first collegium after I took over as CJI, consisting of my brother Justice Surekant and Justice Oka, we recommended a name of a scheduled caste judge from the most backward areas of Karnataka to be a Chief Justice of Manipur High Court, who has taken over as the Chief Justice yesterday morning. Justice Oka brought to his courtroom something truly exceptional, that is a rare combination of sharp legal acumen and deep human empathy. His judgments were never just about interpreting the law, they were about understanding lives, resolving real problems, and making justice feel accessible to everyone. An environmentalist at heart, Justice Oka's commitment to ecological preservation has been powerfully reflected in his judicial work. During his time at the Supreme Court, Justice Oka has also consistently reinforced the importance of judicial accountability and efficiency. Often speaking about the need for reducing judicial delays and ensuring that justice is neither delayed nor denied. His views on judicial reforms, particularly in relation to trial courts, have initiated an important discourse on how to bridge the justice gap in our legal system. Justice Oka also made a significant contribution on the administrative front of the Supreme Court. He served on several key committees, including those on case flow management, finance, promotions, security, and editorial. His leadership was instrumental in drafting model rules for case flow management across all court levels and in shaping plans to reduce arrears in courts nationwide. On a personal note, Justice Oka's demeanor, both on and off the bench, has been an exemplar of humility, grace, and scholarly engagement. Many of us have witnessed his meticulous attention to detail and his unfaltering patience in hearing each side before delivering his considered opinion. Justice Oka's retirement today does not mark the end of a significant era, but beginning of new innings in pursuit of service to the society and the nation. Justice Oka's judgments will be studied for their intellectual rigor, fairness, and commitment to justice. His contribution to environmental jurisprudence and constitutional values of liberty, justice, equality would leave his inedible imprint. His leadership during challenging times, especially during the pandemic, will stand as an evidence of his vision of a responsive and resilient judiciary. The last 2 days' event are a testament to his unwavering commitment to judiciary. Day before yesterday, the lawyers from Maharashtra had organized a function to celebrate my elevation as a CJI and also to bid farewell to Justice Oka. So after the function was over, we stayed over for dinner along with our other colleagues from Bombay or associated with Bombay. And since he had to deliver his judgments, he excused us and went for writing the judgments. When I went home at around 12:30, I received a call from him that such an unfortunate thing had happened, and he said that he is leaving tonight itself. This function was scheduled to be held yesterday. Therefore, I called an emergency meeting of all the colleagues in the morning. There were quite a few views whether he will come back or whether the function will be held or not. But I was sure that after attending the funeral, he'll be back by the evening to attend the court the next morning. Even after his father's death, he had taken leave only for a day and returned to his work. As all of us have already paid homage to his departed mother, I read it, one of the Marathi newspapers today, that the strong will, the determination, the courage are some of the qualities he has inherited from his departed mother, Vasanti ji. I'll be failing in my duty if I do not mention the contribution of Anuja Vaini, the better half of Justice Oka. As all of us know that the lives of judges as well as the lawyers are demanding, and therefore the home front is entirely on the better halves. She had not only nurtured the children, but made them reach a position where they are highly successful in their careers. Without her support, I do not think that Justice Oak could have been what he is today. His elder son Akshay is a postgraduate from the USA in industrial engineering. He is working in booking and .com in Amsterdam. His daughter-in-law Divya, the only connection with law in the family, is LLM from Leiden University and is working as a law officer in a bank in Amsterdam. His younger son Akhil is a postgraduate, has a postgraduate degree from London School of Economics and works as a political analyst in political consultancy services. As everybody expressed in the morning, Justice Oka will have a longer time for his family. I have my own doubts, knowing him for past 40 years, but I, behalf of on all of us, urge him that at least increase the share of time for the family. As we bid farewell to a truly remarkable judge, we express our deepest gratitude for his invaluable contributions to the judiciary and the nation. Justice Oka will continue to inspire future generations of lawyers and judges to uphold the Constitution and serve society with integrity. Justice Oka, as you move on from your judicial duties, we wish you, the members of your family, all the happiness, good health, and fulfillment in your future endeavors. Thank you very much.
Thank you, sir. Now I request a truly exceptional individual, a distinguished judge, Honorable Mr. Justice Abhay Oak, Judge Supreme Court of India, to kindly address this gathering.
Justice Bhushan Gawai, Honorable Chief Justice of India, my sister and brother judges in Supreme Court, my sister and brother judges from Bombay High Court, my brother judges from Karnataka High Court, retired judges from Bombay High Court, Mr. Vikas Singh, newly elected President of Supreme Court Bar Association, Mr. Rahul Kaushik, Vice President, Pragya Baghel, Secretary, senior members of the Attorney General, the Solicitor General, senior members of the Bar, former President Mr. Kapil Sibal, and members of the Bar who are present in such large numbers on the last working day before summer vacation. Last few weeks were a difficult time for me. The reason was I had too many judgments to write, and therefore my entire team and myself, we are working round the clock. I thought that I'll complete my judgments by Wednesday, and Thursday I can pen down my speech today, but that was not to happen. Therefore today, in the afternoon, after I went back from ceremonial hearing, just sitting here, I jotted down few points. Last 2 days, everybody has been asking me, how do you feel when you are going to demit office? I think President said what I said in Bombay, or President or Vice President, that I don't look forward for freedom, because I always believed that judges have freedom to do justice, and that freedom is not available when you are not a judge. Therefore, there is of course a tinge of sadness in my mind that I will be demitting office of Judge of the Supreme Court of India. I have been a judge of 3 constitutional courts for last 21 years and 9 months. And when you are a judge of a constitutional court, you get so much involved with your work that judgeship becomes life, and life is judgeship. And that is one transition I'll have to face, and I will have to find out whether there is any life outside the justice. And I'm sure that I'll be able to do that and lead a constructive life ahead. Maybe after a few days, after my retirement, I'll be able to think rationally about my future course of action or how I'm going to lead the future life. It is often said that when a successful lawyer becomes a judge of High Court, he makes sacrifice. I don't agree with this concept at all. Maybe sacrifice may be in material terms, in the sense that whatever good income you have as a lawyer, that income gets reduced. But I always say so in all judicial academies. I've been teaching in judicial academies for the last 15 years. That when you join judiciary, you may not get that kind of income which you get as a lawyer. But the work satisfaction you get, that can't be compared with your career as a lawyer. And judgeship, it's a beautiful concept. When you are a lawyer, you may be a very good lawyer, but your performance is constrained by your opponent, your own client. Sometimes you face very hostile judge. So you may be a good lawyer, but there are several constraints on your performance. But if you are a judge, when you sit in the court, nobody controls you except the Constitution and the law and your own conscience. And therefore, I always say so in judicial academies that accepting office of a judge is not at all a sacrifice. But there is a sacrifice involved, not on the part of person who assumes the great offer which comes from the Chief Justice. The sacrifice is involved on the part of family of the judge. Brother Justice Gawai talked about my wife Anuja. Perhaps the maximum sacrifice was by her. One more sacrifice I want to tell you, very few people know about it. My father was a very distinguished lawyer, civil lawyer, practicing in one of the most prosperous districts near Mumbai, where there is a lot of commercial work. The day my appointment came in 2003 as a judge of the Bombay High Court, he was on the height of the profession. Immediately he told me that he is going to quit the practice. He not only left the practice, he never entered the premises of the court. He continued to sit in his office, and whatever consultation work came to him, he continued to do that. So, maximum sacrifice is by my wife, Anuja, my parents, and if you want to succeed as a judge, if you have botheration at your home front, you won't be able to do that kind of work which is expected of you. So the entire family, my parents, my wife, my children, my brother, Dr. Ajit Oak, his wife, Varsha, as a family unit, they supported me. And in a lighter vein, I want to thank my sons for a different reason. That both of them kept distance from the legal profession. That can be a great relief for a judge. Therefore, when we talk about the work done by the judges, we must also give credit to their families, because their sacrifice is the real sacrifice. A person who occupies the office doesn't sacrifice anything. On 28th of June 1983, I started practicing in district court at Thane. Frankly speaking, I never thought at that time that I'll be able to practice in High Court, because my father was so successful on the civil side. He was a very leading lawyer. But somehow I could get an opportunity to start practice in High Court in 1984-85. My father's dear friend and former judge of the Bombay High Court, Justice Tipnis, he happily accommodated me in his chamber, but I could work with him for only 1 year because he was elevated. And then started my long journey in Bombay High Court. I'll come to that little later. And as a judge, funny things happen to you. I remember from the beginning of 2019, maybe senior lawyers, maybe senior judges used to talk to me and tell me, very likely you are going to become a Chief Justice. Somebody told me that I'll go to Jammu and Kashmir. Somebody said I'll go to Kerala. Somebody said I'll go to Mizoram, Manipur, Tripura. But surprisingly, nobody told me that I'll become Chief Justice in Karnataka. But Collegium thought so. And there's a very interesting story about my elevation to Bombay High Court. I'm not going to tell that story to you because other day in Bar Council function in Bombay, Justice Gawai has publicly assured that he'll come out with that story after 24th November. That story is only part of it I'll tell that in 2000 or 2001, myself and Justice Gawai were called by different senior judges and where our consent was taken, informal consent was taken. The subsequent part of the story, I'll leave it to Justice Gawai to tell. I'm not going to tell you. But only fascinating part in today's contest, I want to tell you that my name was recommended on 15th of February 2003 and warrant was issued on 14th of August 2003. Perhaps you may not be able to believe that this can happen in 6 months. Today it takes maybe 2 years, 3 years, I don't know. It may be more also. So it was a great privilege for me to go to Karnataka. And before I went to Karnataka, it was a great learning experience for me to be in Bombay High Court. I must acknowledge my Chief Justices. When I was in practice, I was purely a civil practitioner, mainly practicing on civil and writ side. But my Chief Justices made me work on the criminal side. And they ensured that I work on all branches. I had done trial work in Bombay High Court. I had sat on the company jurisdiction. I sat on the insolvency jurisdiction, all jurisdictions. I got experience because of great Chief Justices which I had. And therefore, my task in Karnataka was very easy. In the afternoon, Madhavi Dhiman referred to something which happened in 2006. But I believe that there are few things which must be kept secret. And perhaps why she said that, I know that she felt that perhaps I may say openly what happened at that time, but some other day and some other occasion. When you undertake a long journey by aeroplane, there are always turbulences. There were turbulences. I remember in 2017 something happened. And the Bombay Bar is so strong and so powerful, they fight fiercely for independence of judiciary. Something happened in August 2017, and within 72 hours, Bombay Bar Association passed a unanimous resolution condemning those who interfered with the interfered with the process of justice. So every time, I must acknowledge that every time, Bombay Bar firmly stood behind me. Same is Bangalore. Mr. Ranganath is here, who was president of the Bangalore Bar Association. He always supported me very constructively. My experience in Bombay helped me to work in Karnataka. And again, few funny things I must tell you. From the year 2000, stories started appearing in newspapers that Supreme Court is going to consider, so Collegium is going to consider several names for elevation. So in 2020 and 2021, all those newspaper reports used to appear, but one name was absent in that was my name. Therefore, August second week, it came to me as a shock when the then Chief Justice of India said that my name is being recommended by the Collegium, because psychologically I was prepared to work hard in Karnataka. I had drawn action plan, what I will do till May 22 before demitting office. As I said, it was a great journey in Bombay High Court. I got a chance to work with great senior judges. My career began with Chief Justice C.K. Thakkar, one of the greatest judges I ever seen. He taught me everything starting from how to take notes, how to prepare notes when you read a file at home. Then I had a great honor to sit with Justice Ajit Shah, from whom I learned nuances of the writ jurisdiction. And after I started presiding over bench, I had fantastic colleagues in Bombay High Court. Some of them are here. Justice Sadhana Jadhav is here. Justice Revati is there. My good friend Gautam Patel is here. All of them shared bench with me. And I learned so many things from them. And they contributed very actively to whatever I did as a judge. Justice Gautam Patel showed me, or rather, tried to bring about improvement in me and making me laugh while sitting on the bench. Today is not a very serious day. Therefore, only one thing which Justice Gautam Patel said on his farewell I want to share. He was a typical original side lawyer. And we were on one page always, but we differed only on costs. Because he had those concepts of original side about the amount of cost. Some of you must be remembering it. I used to say in open court, if you don't withdraw, I'll follow standard of Bombay High Court original side to impose costs. Some of you must be remembering it. I said so in open court. So we used to always differ on cost. He thought that I am fixing very lower amount. So there was one frivolous petition. I tried and convinced the lawyer to withdraw it. He would not withdraw. So therefore, I dictated the whole judgment. I looked at Justice Patel. I said, how much? He gave me signal like this. So I dictated 5 lakhs. He was taken aback. He said, I said 50,000. But I must say that order was confirmed by Supreme Court with cost of 5 lakhs. So it was a fabulous journey in Bombay High Court. Every judge, I won't call them as junior judges. I learned something from every judge. And then my journey started in Karnataka. My colleagues are here. Some of them sat with me. And in Karnataka, I decided one thing, that I'll start from 2018 batch. And I will allow every judge in order of seniority to sit with me. And in pandemic, I ensured that all judges sit with me during pandemic. So it was a fantastic journey in Karnataka because of my colleagues. I mean, because there is so much to learn if you go to other court. I remember my first day in court hall number 1 in Karnataka. Something basic I had to learn. Because in all high courts and in Supreme Court, you will find that senior judge sits on the right-hand side and junior judge sits on the left-hand side. In Karnataka, exactly it is reverse. So I sat with Justice P.S. Dinesh Kumar. I almost occupied the wrong seat on the first day, but he corrected me. So it was a great journey in Karnataka also. And even in Supreme Court, I must thank all my Chief Justices and especially my colleagues who sat with me in division bench after I started heading a bench. Justice Bindal, Justice Sanjay Karol, Justice Pankaj Mittal, Justice Ujjwal Bhuyan. I must say that he sat with me almost for 10 months and contributed a great extent. Had such a pleasant experience with Brother Augustine Masi. So all colleagues in Supreme Court were so good, and I had to learn. I learned from everybody. There's one remarkable thing about my long journey, which many of you may not believe, that during this long journey, I never delivered a single dissenting judgment. And even my colleagues never delivered dissenting judgment. One exception is, one of my brothers did it 2 days back. But I say exception proves the rule. So the rule is that I never delivered dissenting judgment, my colleagues never delivered dissenting judgment. there are so many things which I want to say. I started by saying something which Madhavi Diwan said about 2006. In fact, during last few days, my office is receiving requests from my friends in media that I should give interview. I have taken a stand that, firstly, talking to media when I'm holding office is out of question. I never did that. I never want to do that. But I had told them that I will need some cooling period of about 2 to 3 months. The reason is, today I speak to media, my mind is full of emotions because I'm demitting office after working for about 22 years. So I may say something, end up in saying something which I should not be saying. So I told all of them that please give me 3 months' time. I'll reflect upon my career and I'll be in better frame of mind to speak to media. The reason is I firmly believe that when you are in office, you are bound by constraints. But even if you demit office, after you demit office, you have to show some constraints. You don't have that kind of freedom which any other person has. And therefore, persons in media, today also I met few media persons, with folded hand I told them that I won't speak to them. And this was the reason that a cooling period is required. Now coming to judiciary in general, I don't want here to only express my emotions or I tell you how was my journey, but I had to carry something further. During last 21 years or 22 years, what I felt was, I genuinely felt that the Supreme Court and High Court, we had neglected our trial and district judiciary. In fact, that is the backbone of the judiciary. Those are the courts of common man. And therefore, I am very glad that the then Chief Justice appointed a committee to prepare action plan for disposal of cases in our trial and district courts. We have huge pendency in trial and district courts. 30 years cases are pending, 35 years cases are pending, 40 years old cases are pending. So we devised an action plan. Brother C. Vikramnath and Brother Dipankar Dattu, they are part of that committee. And we have been monitoring implementation of that action plan because time has come when we should concentrate on our trial and district courts because that is where common man gets justice. And therefore, we need to change our approach. I must have attended several workshops, several seminars which discuss the judicial system. And when we discuss judicial system, sadly we discuss only High Court and Supreme Court, but we completely ignore our trial courts and district courts. Therefore, I have always said on public platforms, please don't describe any trial court or a court of civil judge as a subordinate court. No court can be subordinate. That is against our constitutional ethos. So that is one area where we'll have to really work hard. The second area where we'll have to work hard, which I said in one of my judicial orders regarding policy on bail. Every high court, every bigger high court has pendency of criminal appeals. 20 years old, 25 years old criminal appeals are pending. 20 years or 25 years old first appeals and second appeals are pending. But that's the basic grassroots level litigation we have. And court like Allahabad is always working with half the strength. Something needs to be done urgently. I always felt, especially in criminal matters, that we sitting in High Court give priority to appeals against conviction of those who are in jail. We forget the appeals of accused who are on bail. So 20 years after a person is released on bail, you deal with 302 appeal. And then if you want to confirm the sentence, it's very harsh because you have to send somebody to jail after a gap of 20 years. So these are the areas, and especially even civil matters. If partition suit is going to take 30 years or 40 years, what relief we are going to give to common man? So these are the areas where we need to work very hard. In fact, we have made endeavor to, I must again thank the Chief Justice for that purpose, endeavor to devise action plan for disposal of old cases in high courts. Of course, high courts are constitutional courts. Therefore, we have only given that as a suggestion. So these are the few areas on which perhaps we'll have to work. Because sitting in Supreme Court, we can't be thinking only about Supreme Court. We have to think about common man, common litigant. And when we think about common man and common litigant, we must think about our trial and district courts. About Supreme Court also, I want to say something. I am very happy that Chief Justice Khanna took us on the path of transparency. Chief Justice Khanna took every decision by taking into confidence every judge of the Supreme Court. My dear friend Justice Bhushan Gawai has democratic values in his blood. His father was chairperson of Legislative Council in Maharashtra. And as I said in Bar Council function, in practice days, I was to appear in many political matters. So every political leader used to come to me and used to say that they are not seen Democrat like his father. And therefore, I am so happy that Justice Bhushan Gawai is the Chief Justice, and therefore I am going to take liberties of making few suggestions. I am not going to make demands like Mr. Vikas Singh, only few suggestions. And before I make those suggestions, perhaps you have seen the approach of the new Chief Justice. The practice of letters has returned, and many other decisions which he has taken. And he has taken those decisions in full court meeting, not in his own chamber. One difference which I felt between the High Courts and Supreme Court is, High Courts, of course, Chief Justice is the master of roster. But in High Courts, the High Courts function more democratically than the Supreme Court, because there is an administrative committee in place of first 5 judges. And that administrative committee takes major important decisions regarding the administration. The High Courts function through committees. Somehow I found during last 3 years and more that the Supreme Court is Chief Justice centric court. And I think we need to change that, because Supreme Court is a court of 34 judges who come from different areas of our country. And therefore, the image of Supreme Court as a Chief Justice centric court needs a change. And I'm not giving you a promise, but I'm sure that you will see that change from the new Chief Justice. The other aspect which always bothered me, bothered me in Karnataka also, that why only selected matters should be listed. And therefore, thanks to my senior colleagues, Justice Nagaratna, Justice Arvind Kumar, I got fantastic support from them. And in pandemic, we tried to introduce auto rating system. So nobody is supposed to mention any matter. All cases will be listed automatically, whether objections are rectified or not. And therefore, we must do something like this. Otherwise, why people complain that why some case is listed on the next day, but some other case remains pending for 20 days or even more than that. And perhaps one solution which I found was, in High Court, there is a fixed roster. And once there is a fixed roster, even that does not give discretion even to the Chief Justice. All matters are listed before appropriate benches as per the roster. After having worked in constitutional courts for almost 22 years, I believe in one thing. We cannot have better listing unless we reduce the manual intervention to the minimum. And we have AI technology, we have other technology, we have softwares, that can really help, so that the listing must become rational. And nobody should have any grievance that why case A is being listed early and why case B is not being listed early. These are few areas where we need to work on. Because ultimately, we must remember that Supreme Court is not only constitutional court, it's an appellate court. And therefore, appeals of common man come to this court. And therefore, to give relief to the common man, we should have a system of listing which will rule out manual intervention. Before I close, I am indebted to so many people who have worked around me. I'm not going to say about high courts because then list will be too long. I started with my family. I already given all the credit to them. My own family, my parents, my brother, his family. But the secretaries, my secretaries at home, they are willing to work from 8:30 in the morning to 11:30 in the night, and they are willing to work smilingly. The ministerial staff in my house, they are also very enthusiastic. Because thrice a week I listed MC Mehta case, and lifting files of MC Mehta case, you require trained weightlifter. So all of them were extremely cooperative. My court staff, the court master, the secretaries in the court, they're very, very effective. I used to list so many matters and they worked absolutely efficiently. The staff working in the house, they loved me, they respected me, they looked after me and my family. So the entire staff which is assigned to me, I can't forget my PSOs also. They were simply excellent, and without their cooperation, I could not have done even 50% of work which I had done. And I can't forget my law clerks. At first batch of law clerks, now some of them are back with me. They simply come and sit in my office where they want to give company to me. But my law clerks were simply fabulous. My interns were fabulous. In fact, I want to share this publicly. There are occasions where my law clerk worked in my office till 4 o'clock, 4:30, 5 a.m. When they knew that I start working early in the morning, so I used to get early morning knock on my door. I used to find law clerks standing outside with some notes or something. So I must give credit to all of them. I wanted to take names of all my staff members, all members of registry. They're also extremely helpful. But then my speech will be endless, and somewhere I have to end. By bona fide mistake, I may have omitted somebody. And I hope that whosoever is omitted, they will pardon me. Before I close, I must thank the members of the bar. I never expected this last working day, when the hall is full, people are standing, when the first balcony is full. I never expected that on last working day. I thank all of you for your cooperation. I know that sometimes it was difficult to appear before me. In the ceremonial sitting, it was said, but it was said very sweetly. But all of you went out of the way to cooperate. I must also thank all the members of the bar who work as amicus, because I handle a large number of PILs. I must thank all of them. So I thank all of you from my bottom of heart. And I will say that even if I am demitting the office, my commitment to the cause will continue in some other capacity. I will always devote time to the cause of justice. Thank you.
Thank you, sir. Thank you, sir, for sharing experience with us and guiding us. Now I request Mr. Kapil Sibal, Senior Advocate, to say a few words and also recite a poem written by him for Honorable Mr. Justice Abhay Oak.
My Lord, the Chief Justice of India, Justice B.R. Gawai, my Lord Justice Abhay S. Oak, the learned Attorney General for India, Vikas Singh, President of the Supreme Court Bar Association, Rahul Kaushik, Vice President, Pragya Baghel, Secretary of the Bar Association, Bipin Nair, President of the SCORA, distinguished judges of the Karnataka High Court, distinguished judges of the Bombay High Court who are present here, retired judges present here, senior members of the bar, advocates on record. This is a very tough moment because we are bidding farewell to a judge who has won our hearts while he was here. Just think about it. Why do we remember judges? And if you go to the history of the court, what are the great judges that you think of? And you will realize that there is a thematic connection to all that. All judges who protected the citizens' freedom have always been remembered. Think of Patanjali Shastri. Think of A.K. Gopalan. Think of Keshavnant Bharti case. Think of Justice Bhagwati's great judgments on Article 14. So all the great judgments of this court have a thematic connection, which is the protection of freedom. And in that pantheon, Justice Oak, you will be in line. You mentioned that you never gave a dissent while you were a judge. You actually rank along with Justice Krishna Iyer of the Supreme Court, who also never gave a dissent. And about your not being in the media, I can assure you that even if you say nothing, the media will say something about you. That is the character of the media in this country. I don't want to take very long. I don't want to take very long because, as it is, some wonderful speeches have been made about you. But I will certainly say a few things. And I will start with saying that our constitution makers realized that the conflict between power and protecting citizens is part of judicial decision-making. That conflict will be there before every judge. In a sense, the history of civilization is a conflict between the desire to dominate and the desire for emancipation. This is true of the desire to get freedom from the dominance of colonial powers. It is the desire for women to be free in the context of the mindset, the misogynistic mindset in our society. It is desire for the less privileged classes to break the shackles of dominance. It's the desire to reject cultural dominance, political dominance. That's the history of civilization. And courts exist to ensure that systems do not dominate the citizen of this country. And it is those judges who protect the freedoms of the people of this country that will always be remembered. The journey of any judge in this court is tested on the anvil of his or her ability to strike a balance between the necessity of curbing an individual's freedom and zealously protecting it from arbitrary state action. The run-of-the-mill matters that come to court relating to civil disputes, corporate legal wars, are not central to the life of the individual. Every human being cherishes freedom in all its multifarious forms. The court is the gendarme, ensuring that the dignity of the individual in all its manifestations is safe even from non-state actors. We cherish the journey of judges who do this. Justice Oak, you passed this test with flying colors. Seldom have we seen a judge seeking accountability of every state action which is found to be suspect. Seldom have we seen a judge in court who has expanded the concept of liberty in the face of laws designed to emasculate our freedoms. Your journey as a judge and your passion for liberty in the context of our constitutional values is a benchmark which will be remembered when the history of this court is written. For the heart and soul of this court, its greatest moments and the greatest judges are remembered for their actions in defending liberty and personal freedoms of the people of this country. The judgments that are remembered are the ones in which judges defended fundamental rights against incursions, from Fazal Ali's dissent in Gopalan to Vivian Bose's principle that Article 14 militates against arbitrariness. In State of West Bengal versus Anwar Ali Sarkar, to the inviolability of Part 3 in Golaknath, to the basic features doctrine in Keshav Nand, to H.R. Khanna's fearless dissent, ADM Jabalpur, to Maneka Gandhi, to Jeevan Reddy's majority in Indira Sani, and to Sabarwal's formulation of the Golden Triangle in Coelho. You, Justice Oak, have earned for yourself a place in this pantheon of great judges. You will be remembered for your candor, your transparency, your forthrightness, and your ability to unveil the motivations involved in the exercise of power to diminish human freedoms. The battle between the state and the citizen is per se unequal. The state has all the power and machinery to ensure that its will becomes a command. And the only institution that can deal with this command is a judge who tests it on the anvil of our constitutional freedoms. When the history of this court is written, there will be a brand oak. A brand oak chapter which will inspire future generations. I wish you all the best for the next chapter in your professional and personal life. And you're right to thank your family, your wife, Anuja Oak, the members of your family who have sacrificed, your father who has sacrificed. That's the part of your DNA. And you have done us all proud. There are very few judges who depart with the kind of affection that you've seen today, this evening. But let me end, this is the ritual that I perform, with a little poem for you. Just a few of you who came our way make us feel secure. Keeping our freedom's flame alive, your instincts pristine pure. That is the kind of judge we want for justice to prevail, calling a spade, upright, forthright, and unafraid. Those meandering confronted with, please answer yes or no. Any attempt to prevaricate, not a safe way to go. Passion for law runs through your veins and justice pumps your heart. Across the bar, exception none hold you in great regard. Powers who exceed their brief acting with impunity tested all such actions on their constitutionality. A few of those who dare to bowl a googly in your court, you cited it before they bowled, handle it with comport. An unsteady judicial ship needs judges who give us hope. You've set the tone by judgments referred to as brand oak. For you have left a legacy that's hard to ever match. Your judgments have such clarity, rendered with quick dispatch. The candor of your judgments will reverberate for years, for in our hearts their melody will constantly endure. It was evident that you believed that rights have primacy. We're always in the forefront in our tryst with destiny. Thank you very much. I just want to hand over, if you don't mind. So if I may just.
I also request Mr. R. Venkatramani, Learned Attorney General for India, to also to gift a book to Justice Oak. Now I request Ms. Aparna Bhatt, Senior Advocate, to read the message given by Honorable Justice Abhay S. Oak, Judge Supreme Court of India, for the members of the bar.
My Lord the Chief Justice and other judges of the court, and everyone present here. I'm not addressing everyone because to save time. I think it's my privilege for having been asked to read Justice Oak's message to all of us. Sir, I must also say that there's not a single lawyer in this court or in Karnataka High Court and Bombay High Court who has one complaint against you. And I think that's a very rare feat for us. We are so grateful, sir. And I thought it's my privilege to have appeared before you. Let me read the message now. I personally feel that a message to the bar can be given by only great jurists. Therefore, I do not think I'm worthy of giving any such message. Without giving any message, I take this opportunity to express my views. This year, on 28 January, the Supreme Court of India completed 75 years of its existence. Instead of celebrating the occasion, we must introspect. The citizens of India had very high expectations from this court. Though no one can deny the contribution of this court, my personal view is that the Supreme Court has not fulfilled the expectations of the citizens of India. Today, our court has a pendency of more than 80,000 cases. Our court is not only a constitutional court, but it is the highest appellate court of the country. That is how the filing of cases in this court is ever increasing. We have sanctioned strength of 34 judges. Even with the sanctioned strength, we are not in a position to control the arrears. Joint efforts of the bar and the bench are required for reducing the arrears. In my humble view, members of the bar must realize the importance of brevity in pleadings and submission before the court. Brevity is always a hallmark of great advocacy. We must have a time limit on oral submissions. The verbose and lengthy submissions result in long judgments. Our judgments must be brief and precise and easy to understand. Unless we adopt this practice of limiting submissions, we'll not be able to meet the challenges before us. It is high time all of us realize that the time of the court is very precious, and therefore, our effort should be to save the time of the court. All the stakeholders of the legal system will have to make efforts to bring down the cost of litigation. The standard of fees of advocates has considerably gone up over the last few years. Therefore, not only poor people, but also those who belong to the higher middle class find it extremely difficult to litigate. The quality of legal aid leaves much to be desired. Therefore, it is high time successful members of the bar and senior advocates come forward and conduct at least 5 legal aid cases every month. The judiciary is passing through a very difficult phase. The credibility of the judicial system is being questioned from many quarters. There is no point in trying to give a reply to such criticism. The only fitting answer to the criticism can be given by the collective efforts of the bar and bench to ensure that quality justice is rendered expeditiously. The criticism of the system can be answered only by better performance. Therefore, it is my appeal to the bar to rise to the occasion and to support the cause of justice. Justice Oak. Thank you.
Thank you, Aparna ma'am. To present a memento on behalf of SCBA to Honorable Mr. Justice Abhay S. Oak, Judge Supreme Court of India, I request Mr. Vikas Singh, President, Mr. Rahul Kaushik, Vice President, and all office bearers of the SCBA to join us on the dais. I request Mr. Minesh Dubey, Joint Secretary, SCBA, to give vote of thanks.
We are grateful to Honorable Chief Justice of India, Justice B.R. Gavai, Honorable Justice Abhay S. Oak, Justice Supreme Court of India, Honorable Judges of the Supreme Court, Honorable Judges of the High Court, Sri R. Venkat Ramani, Attorney General for India, and Honorable Retired Judges of Bombay and Karnataka High Court. We are also thankful to Anuja Ma'am, wife of Justice Oak, Sri Achay Oak, Sri Akhil Oak, son of Justice Oak, Ms. Divya Dhage, daughter-in-law of Justice Oak, and other family members for accepting our invitation. We are also thank Sri Tushar Mehta, Learned Solicitor General of India, other distinguished law officers, Sri Vipin Nayak, President, ISKORA, other office bearer of ISKORA, Mr. Kapil Sibal, former President of SCBA, Mr. Sukumar Parjoshi, Ms. Rachna Srivastava, Vice President of SCBA, Mr. K.C. Kaushik, Mr. Rohit Pandey, former Secretary of SCBA, Mr. Swamijit Pani, Ms. Neena Gupta, member of GICC, and Mr. Devrat, former Secretary of ISKORA, senior advocates and members of the bar. It is a profound privilege to stand before you today and extend our heartfelt gratitude on this occasion, the farewell of Your Lordship, Justice Abhay S. Oak, Judge Supreme Court of India. Your Lordship tenure has been marked by unwavering dedications, remarkable legal acumen, and steadfast commitment to constitutional values. Your judgments have not only shaped jurisprudence, but have also inspired generations of legal professionals with their clarity, fairness, and deep-rooted sense of justice. On behalf of everyone present, we extend our deepest appreciation for Your Lordship invaluable contributions to the judiciary. Your wisdom, integrity, and pursuit of justice will remain a guiding force for all of us. Your Lordship, we wholeheartedly wish you a life filled with happiness, good health, and continued fulfillment in all your endeavors. I extend my sincere thanks to Learned Secretary General Sri Bharat Parasar, other registrars of Supreme Court, and the media persons for their presence and support in making the function successful. I request all office bearer of the SCBA to come on the dais for photograph. Please join us for high tea on the ground floor.